Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In this episode, we speak with Advocate Sarah Saunders from the Ravona Group of Advocates who represented the respondents, the employees in MTN versus Njokweni and others in the Labour Appeal Court, where the court affirmed that employees are automatically transferred to a new employer under Section 197 of the Labour Relations Act need not tender their services to enforce their rights. The case arose from MTN's 2010 insourcing of its call centres. Although the court confirmed the work's entitlement to back pay, it ruled that part of their claim had prescribed. As prescription began when they became aware of the facts giving rise to the debt and not when their employment was later confirmed by the court. Sarah Saunders is here today to talk to us about this, having acted in for the respondent. Sarah joined the bar in 2010 and practices mainly in labour and employment law before appearing before the Labour Court, Labour Appeal Court, CCMA and bargaining councils. She is a CEDR accredited mediator, an advocacy trainer at the Johannesburg Bar, and lectures in labour law both at the University of Johannesburg and Stellenbosch University. Sarah has also been periodically invited to act as a judge of the Labour Court of South Africa. So Sarah, diving right in, thank you first of all for joining Debbie and I. You appeared for the respondents in this matter. Can you give our listeners a quick overview of what was at stake in this case?
Hi, Debbie and Aisha. Thank you for having me. Breaking it down to its bare bones, what was at stake here was approximately 7 years of pay for these employees. To give an overview of the background of the matter, in November of 2010, an outsourcing arrangement was cancelled. MTN decided to take control of a call centre, and on the 1st of December 2010, a variety of employees were all dismissed. Now, the proceedings unfolded in two groups. The first group of employees were all represented by a trade union, and there were approximately 50 of those employees, and those 50 employees launched a declarator in the Labour Court saying that their employment had been transferred in terms of Section 197. They were initially unsuccessful in the Labour Court, and then ultimately the Labour Appeal Court confirmed that this was a 197 transfer on the 21st of April 2015. Now that date is quite an important date, and I'll come back to that shortly. But in parallel to this, what happened was my clients, a group of 6 employees who were not members of a union, they did not have the financial backing of a union to litigate on their behalf, they were watching in the background to see what had happened. They were also part of the group of employees who were dismissed. Factually, all the background facts were absolutely identical. And they were not a party to what we call MTN 1. MTN 1 was the judgment handed down by the Labour Court in April of 2015. They then, as a result of this Labour Appeal Court judgment, launched their own declarator in October 2016, some 18 months after, seeking exactly the same relief, that they were going to be told that they were employees as well, and that they were also entitled to have been transferred by operation of law under Section 197. And on the 6th of December 2017, the Labour Court made a finding, Judge Lagrange made a finding that that was exactly what had happened, and these employees had been transferred by virtue of Section 197. Now, very importantly, the MTN did not appeal that judgment. They'd appealed a series of other judgments in respect of the other employees, but they didn't appeal this one. On the 12th of December 2017, MTN said, right, guys, come back to work. You're all going to work in Joburg. And one of my clients accepted that offer of employment. He's still employed there. He's been employed since 2017, or actually during the course of, prior to the 2010 transfer, of course. The 5 others all said, no, we were employed in Durban and we want to be re-employed back in Durban, and we tender our services there, which MTN didn't like. And in respect of those employees, a disciplinary process unfolded, and ultimately they referred the matter to the CCMA, and the matter was settled in March of 29 in the CCMA in respect of those 5 employees. What happened, importantly though, and this was an ongoing dispute, first, both in respect of those original 50 employees and also the 6 employees who were my clients, is that MTN was incredibly resistant to paying the back pay, essentially the amount of money that was owing from the date on which the transfer took place by operation of law, which was the 1st of December 2010, up to and including the 21st of April 2015, and that was in respect of the MTN 1 employees. That was the date on which the LAC said, right guys, you've been transferred by operation of law. And in the case of my clients, they refused to pay the back pay up till the date of Judge Lagrange's judgment on the 6th of December 2017. So what this matter ultimately boiled down to was, what was the entitlement for my 6 clients for the back pay for a period of, essentially that period from December 2010 to December 2017. That was the question that was before the court. The statement of claim was referred to the Labour Court by my clients. The Labour Court found in favour of my clients, and then that was taken on appeal by MTN during the course of, and that was argued in May of 2025.
So I want to take us back a little bit, mentioning Section 197. And I know we're going to get deeper into it as we go into our questions, but Section 197 protects continuity of employment. Just tell us a little bit about, what is the caution for employers, and what does the case say about employers' obligations when they take over a business?
The case doesn't necessarily make any new law in that respect. So the case essentially confirms what we already know about Section 197 transfers, which is that the relationship will continue by operation of law. Whoever the old employer is, they are substituted by the new employer without the employees having to do anything. What was quite important in this matter was that the court found that there was no obligation on the employees to do anything. There was no obligation on them to tender their employment. It expressly found that a tender wasn't necessary, which is a wonderful, wonderful thing for the employees, because the court has now confirmed it's not necessary for them to act in any way to confirm their employment. By operation of law, by the prescripts of the LRA, they are automatically protected should a transfer as a going concern take place in terms of Section 197.
So Section 197 has really given the employees this protection. They don't have to tender their employment, but we have a significant lapse of time here. So this raises the question of prescription, which was an issue in this case. Talk us through the decision in terms of prescription rules, and also what challenges does prescription present for workers, but also for employers, where there's a significant delay in time between the dispute coming before the court and the dismissal or the transfer of a business, as it was in this case.
Prescription challenges that arose in this matter actually became quite complicated, because there were various points at which we debated when does the clock start ticking? So the basic premise is that one has 3 years from which a debt becomes due in which to claim a certain amount. Whatever that debt is, you have a 3-year period of time to claim that amount of money. So if we have a look at the various pivotal dates in this matter, there are a series of them. Does prescription start running from the 1st of December 2010 when the variety of employees were dismissed? All of the employees were dismissed on the 1st of December 2010. So surely there's an argument can be made out that that's when it starts, the clock starts ticking. We then have the question of, well, the 50 original employees who were represented by CWU, the union, they launched their dispute in May 2011. So would the clock have then stopped when that process was initiated? Would it then have stopped in respect of my 6 clients when they launched their dispute, which was in October of 2016? Would it have stopped when there was certainty as to who the employer was? Because up until 2015, we had no clarity as to whether MTN was the employer or the original outsourced employer who was a party to the process as well. So we had a variety of dates that were all in the mix here as to determine when the clock really started ticking. And one of the dates which came into play for the 6 employees in question in this case, they received certainty that they formed a part of the Section 197 transfer on the date on which Judge Lagrange gave his judgment, which was the 6th of December 2017. So our case was that was the earliest point at which prescription could have started running. Now, MTN took a different position. The original position that MTN took was that prescription would have started running on the 21st of April 2015, because that's on the date on which the LAC confirmed in what we call MTN 1. So the very first Labour Appeal Court judgment in respect of the original 50 employees, that was the date on which they confirmed that a Section 197 transfer had taken place. And their take was because the respondents in this matter, the employees in this matter, only launched their claim for this arrear payment on the 25th of April 2018, that the claim had wholly prescribed. We were 3 years, and on their version, 3 years and 4 days late. So on their version, the claim had completely prescribed. What the court ultimately found was that it wasn't the date on which Judge Lagrange made the finding that my clients were employees of MTN. That wasn't the relevant date. The relevant date, in the ordinary course, it's not even necessary to get a declarator because all of this happens by operation of law. What the Labour Appeal Court found in this matter was that the clock was stopped on the date on which my clients brought a declarator. When they launched their application for a declarator in October of 2016, that's when the clock stopped on prescription. And as a result, the 3 years that fell immediately prior to that had prescribed.
You're listening to the Labour Justice Barometer, and we'll be right back.
So you've indicated this doesn't change anything in the law relating to 197. Do you think it has an impact on how the courts are going to view prescription? And I also just, kind of casting your mind back, 2010, I don't even think I can think that far back, but 2015, 2015, roads must fall, fees must fall, 2017, 2 years prior to COVID. What does this mean for our law on prescription and for employers in this regard? Any thoughts on that? And maybe also call centers must surely be under threat in our current climate of AI and other, do you think this has any impact on the concept of prescription and also any threats for call centers or any lessons in this for us, just that significant time delay?
Debbie, there are a couple of elements to your question there. So dealing first with the issue of the time delay is absolutely horrific. And this must be the absolute antithesis of what the LRA intended when it speaks of expeditious resolution, because we're talking about a dispute which has as its origin December 2010. This matter was finalized in August 2025. That's a 15-year period. And it can never be the intention of the LRA that a dispute should take this long. Even though my clients waited a period of 6 years to launch their declarator, and quite a vehement argument was put forward by MTN in this respect to say that they'd sat on their laurels, they hadn't moved fast enough, they'd essentially abandoned their case. That wasn't necessarily the case, because what they were very, very clearly doing, because they mimicked the conduct of the original 50 employees who were originally dismissed, was they were waiting to see what progress the union made. Now, CWU represented all of their employees, all of their members, and they were successful. It took them some time, but they were ultimately successful in April 2015. So that was a two-part process. The first referral to the Labour Court, the second referral to the Labour Appeal Court, and that judgment came down in 2015. So 5 years for the first part of clarity to be obtained. And to a certain extent, the delay was occasioned by the respondents in this matter. They did wait a period of 18 months before launching their dispute. But between October 2016 and obtaining finality in this matter in August 2025, we're looking at a further 9 years. And that's enormously upsetting both for employees and for employers, because employers have their businesses to run. They need clarity on what their financial obligations are. They need clarity on what their staffing obligations are. And employees need certainty on where they stand. Are we employed? Are we not employed? Do we have an entitlement to this money? Do we have an entitlement to jobs? So it doesn't do anyone any good to have a matter which spans that period of time.
So is the lesson here that they should have been a member of the trade union?
It's definitely a part of the message. There's no question about that, because we're talking about 6 employees who don't have the money to litigate the way a company like MTN does. It's definitely a part of the message. These respondents were certainly for a substantial part of this litigation represented on a pro bono basis. It's the only way in which they can litigate, because it's prohibitively expensive and very time consuming, particularly for those who are unemployed. And I don't have any certainty on what they earned, but I can't imagine call center employees being in a position to earn enough to litigate on the scale that this litigation required.
So they should never have been left out in the cold in the first place.
Well, the alternative argument is that they're not union members. You have to pay your subs to be entitled to the benefit. And it was only once they reached once the union had their success, that it was worth the risk for them. But then the hurdle, of course, that they ran into was had their claim prescribed, which is a legitimate counter to the time they took to launch.
So I think then leading on to that, this is where we have to ask our question, which I'm sure you must know by now, Sarah, our Labour Justice Barometer question, where on our scale, where green means progress, orange signals that more needs to be done, and red suggests that this law is completely failing, where would you place this case on our Labour Justice Barometer? Did justice prevail, or did prescription and procedural barriers still tilt the scale against the workers or your clients in this case?
Aisha, I thought that I would find this an easier question to answer if I had a pros and cons column, a green and a red column, and I've literally written them down in green and red. And I'm not too sure on my answer. There are a lot of good elements that came out of this litigation. So I think there's a lot to be said for the strength and the power of union involvement, the enormous benefit that they can bring for their members. It's incredible the work that unions do, and it's incredible the achievements that they can, the litigation, the jurisprudence that they can create for members who would otherwise be completely barred from being able to litigate. And I think that's fantastic. I think the same can be said for attorneys who are willing to act on a pro bono basis. It's very necessary in our profession to have individuals who are willing to act on a pro bono basis to further justice. So that's an incredible benefit. And obviously, these are guys who were ultimately paid a period of 4 years and 2 months, which is an astonishing sum of money. Even for MTN, it's an incredible amount of money. So there was an element of success for them. Did they get their jobs back? Unfortunately, only one of them was successful in retaining his employment. So that's a definite red, veering towards the red scale. From the red scale, the time delay is devastating for employees. Employees shouldn't have to wait 15 years to have clarity on their situation. The transfer took place, as we've said, in December 2010. 15 years later, only then do we have certainty and finality on that. And that could never be what the LRA has envisioned. There was a considerable loss of money as a result of the prescription issue. So obviously a huge amount of money had prescribed on the court's findings. So that entire period between the 1st of December 2010 and the 12th of October 2013, the court found it had prescribed. Now, if the employees were in a position financially or otherwise, to have launched this application earlier, that money may not have been lost to them by virtue of a legal principle that doesn't take into account equity and justice and social considerations. Because prescription is something which is very much set in stone. And unlike the Labour Court, which has a softer touch to it when implementing the law, prescription is very black or white. There's no in between. And that, I think, is an area which doesn't necessarily marry well with Labour principles. The issue of Section 197 operating by matter of law, or the principles of Section 197 kicking in by operation of law, are both a protection and a danger for their employees. Because they operate by matter of law, an employee would have to move quite quickly to enforce it, because presumably the clock is ticking on those prescription principles. But in the same sense, it also says, the case now also says, well, there's no need to tender. Because this protects you by operation of law, you're protected. You're protected indefinitely. You're protected just by being an employee before this all took place. So there are both pros and cons depending on your perspective on how you have a look at that.
So is it safe to say that it's in the orange? I don't know, Debbie, what do you think? For me, from hearing you speak about this, it's orange tilting towards the red. Just from the time alone, I'm thinking 15 years it's an intense number, and that in itself for me is, as you said earlier, this is not what the LRA intended when it comes to, resolving disputes. So Debbie, what do you think?
So, I think it's really tricky when we're litigating really complex legal issues like Section 197, and then we throw in prescription, and then we have employees who are represented by trade unions and those who are not. And then we have a Labour Court and a Labour Appeal Court structure that operate within judiciary constraints, but they are there to provide speedy and efficient labour dispute resolution. I suppose I think ultimately there's a lot of green in the outcome for employees, but the red is perhaps in the lapse of time. But, your hope would be that this does raise flags for employers and that they resolve these matters sooner and that they recognize their obligations sooner and quicker, and that these matters, that the lessons are learned from this and employees join trade unions where they exist. So I think it's a little bit of a combination of all. It's a difficult one to tell. But Sarah, thank you so much for being with us, certainly, and sharing insights that we don't normally have on our shows. We always, armchair reasoning about how the parties were or what were the factors at play. So it was a real privilege to be joined by you today, and I hope that we can invite you back again soon. Thank you for joining us.
Yes, thank you, Sarah. And it definitely won't be the last time that you have to come onto the podcast. So we need to convince you to definitely come back. And everything that Sarah has mentioned today in the podcast will be in our description. And you can find a link to the case and more about information on Advocate Sarah Saunders, because you're doing amazing work. So thank you for actually sharing your insights. And Debbie, I'll see you in the next one.
Thank you for having me. It was fun to delve back into these facts again.
Thanks, Asha. See you again soon. This podcast is not intended to constitute legal advice.